Oh, we'll move down to page 10. Hello, hello, hello. Okay, so today is actually session 4. Can you believe it? Wow. Of the RPA, and it's the final session. So we're actually gonna wrap up the RPA mastery today. Okay. So even though it's quite a few pages, it's already wrapping. You'll see as we get to the end, some of the terms are just very boilerplate, template stuff in most contracts, but we're still going to go over it so we understand the structure of the RPA. So we're going to start on paragraph 14. Okay, because that's where we left off. And then we're going to go from paragraph 14 all the way to the very end. Now, what's interesting is if you've noticed, just like I said in the very beginning in session 1, where I said the RPA is like the GPS, right? It's like the roadmap of the transaction. In fact, we've been on the route, right? Our destination, everybody wants to get to close, right? The close is where we're going, that is our destination. And if you kind of feel, this is the way I've always looked at the RPA, and it's made learning it, teaching it so much better when you kind of look back at even our past 3 sessions and you kind of look at it like it's gone in order of the transaction. So let's stop and think about that, right? Like session 1, we talked about, right, all the terms. That was like all the negotiating terms. And then it rolls over into reports, who's going to pay for what, right? Contingencies. We went over paragraph 8 is all about contingencies. We covered that. We covered seller disclosures, right? Because think about it. Think of the order of a transaction, right? You get through the negotiating terms, boom, it's negotiated. And now what? Now we got to order reports, got to do disclosures. The buyer has, right, investigation rights. We talked about that in paragraph 12. And now we're still going in that order. Now we're kind of putting it all together, piecing it all together, and getting closer to our destination. And 14 is time periods, removal of contingencies, cancellation rights. Because we've already talked about really all the core stuff, right? We talked about disclosures. We talked about buyer investigation. We talked about reports. We already know who's going to pay for what because we did all that in paragraph 3. So now we're like, okay, so now what? So 14 is now going to tie it all together and even talk about what happens if you get off track. What was that? What would that be? Cancellation, right? I mean, cancellation, you can't get more off detour. a detour just completely rerouted. You know how like when you get rerouted, like, sorry, you got to come back around. Okay, so 14, let's talk about this. 14 time periods. What I want to highlight in 14 is that bold, right above 14A, it's that entry paragraph there. And what I want to highlight there, it says, the last sentence, any removal of contingencies or cancellation under this paragraph by either buyer or seller must be exercised in good faith and in writing, always. Okay? In other words, you can't remove some, you can't even if you were to say, hey, my buyer's removing contingencies tomorrow, right? Or an email. No. Okay, that doesn't work. There's certain forms. The paragraph references form CRB, which is removal of contingency removal buyer, contingency removal seller, or what's the other alternative? Cancellation, right? Which we don't like, but unfortunately, it's something that we do have to talk about. Now look at 14B. The buyer review of the documents, repair requests, contingency removal, or cancellation. What I want to highlight there is in B1. And in B1, look at what it says towards the middle of B1. Well, first of all, it reads like this. Buyer has how much time if we leave the default? Buyer has 17 days to perform buyer investigations, everything that we talked about in paragraph 12. Review all disclosures, reports, lease documents to be assumed by buyer, right, pursuant to that paragraph 9B, and other applicable information which buyer receives from seller. And here's the key, and approve how many matters affecting the property? Approve all matters affecting the property. Didn't we say at that time the buyer has the right, to cancel based on any, there's, whenever you use words like any, all, I mean, you can't get more than that, right? So this is what paragraph 14 is reminding us of. The buyer has to approve, or has the right to approve, all matters affecting the property. And now when we look at B2, what does B2 say then? Now that we know buyer has 17 days to do that, well, buyer also within that time, so buyer within 17 days may request that seller make repairs or take any other action regarding the property. And they would do that using what form? Form RR, which is a request for repairs. So let me pause there. Okay. So we just read what? Buyer has 17 days to do, right? All inspections, investigations, review all the reports. And now we get to the point where it says that they have this right to request the seller to make repairs or take any other action regarding the property, and using form RR, request for repairs. But what does the very next sentence say? Seller has no obligation to agree to or respond to buyer's requests. That's super important because that sets expectations. When you're working with a buyer, right? And you already from the very beginning say, hey, buyer, even though the contract gives us the right, you do have the right to ask the seller, right, to make repairs, a credit, lower the price. There's different options. But let us not be caught off guard, surprised, shocked, discouraged, thrown off track if the seller doesn't even respond to it. Because the contract just told us, right? Seller has no obligation to agree to or respond. So when we let the buyer know in advance from the very beginning, it just makes it so much smoother, so that when we're making that request, right, we're not expecting a certain outcome. Okay, because ultimately we don't have control of what the seller is going to decide to do. So that's a very important paragraph. I've had to reference that paragraph so many times when agents are unclear and think that there's something wrong. Like, in other words, hey, listing agent, why aren't you getting your seller to respond? Well, first of all, they don't have to. So as long as we know they don't have to, it's nice to get a response, right? So we know, but they're not obligated to do that. Now, in B3, 14B3, the key there is what I want us to remember is that buyers should never, and they should always know that they're not obligated, and they're actually advised not to remove any contingencies related to the review of documents until after those documents have been delivered, okay? And if they do, right, then obviously they're going against agent advice to do that. Now, B4, 14B4, continuation of contingency. I think I talked about this briefly in our last session. It literally means exactly what it sounds like. Continuation of contingency. This is the paragraph that basically says and means that until we get those contingencies in writing removed, it will continue. Okay, so even though the contract says, right, buyer has 17 days to do this, 17 days, has to remove appraisal contingency, 17 days, loan, right, investigation. This paragraph says that even after the end. It's even how it starts off by saying, so even after the end, so let's just keep reading it. Even after the end of the 17 days. That's basically what it says, because it says specified in paragraph 3L. So now we can just get a really clear understanding. Even after 17 days is really what it's saying. And before seller cancels, if at all, buyer retains the right in writing to either remove remaining contingencies or cancel this agreement based on a remaining contingency. Once buyer's written removal of contingency is delivered to seller, and before seller cancels, seller may not cancel the agreement based on that contingency. Wow. So even after the 70 days, these are those conversations that you absolutely want to avoid. They're not pleasant. I've had to have multiple conversations with sellers that rightfully are upset. It's not a good conversation to have to explain to a seller that after 45 days, 60 days, 90 days of extension on close of escrow, that, yeah, the buyer is entitled to their deposit back. That's not a good conversation. A seller doesn't understand. How is it that I've tied up my property for 60 days and now you're saying I have to give the deposit back? Yeah, because the contingency continues. It will continue until it's removed in writing. So we have to be aware of that. Now we're talking about, so what happens? We already talked about time periods. We understand how that works. 17 days, it's going to continue. We talked a little right now about removal of contingencies. But what about now we get to the point that we don't like to talk about, but now the contract has to outline what we do. Seller's right to cancel. Okay, well, first of all, it must always be in writing, okay, and signed by the seller, can't be verbal. And there's two areas where a buyer has the right to cancel, and it breaks it down for us. It's here in C1 and C2. C1 is buyer contingencies. That's probably the most popular one I think that we talk about, right? In other words, seller's going to cancel if buyer doesn't remove contingencies. That's pretty typical. But then there's also in C2 buyer contract obligations. Oh, so there's a difference. Okay? If you pull up a CR form, which I actually just, to this day, I keep a blank CR form right at my desk because it outlines, right, all the contingencies. If you look at a notice to buyer to perform, which is we're going to talk about, there's something that's called buyer contract obligations, which is what? Everything that we've already talked about in prior sessions, starting from the very first contract obligation, which is what? The deposit, right? If you think about it, what's the very first thing that the contract places on the buyer in regards to performance? The deposit, right? So when we think of those kind of things, deposit, pre-approval letter, okay, removal of contingencies, providing sufficient funds to close, those are all contract obligations. They're not specific contingencies other than the actual removal contingency, but those are contract obligations. That's another reason for a seller to cancel if we stop and think about it, right? Hey, a buyer never made the deposit. So that's what this paragraph talks about. But it's very clear. If you look at both C1 and C2, it says that first, or after, I should say, delivering a buyer or to the buyer a notice to buyer to perform, which on the next page is where we actually talk about that specific form and what that means. So regardless, whether it's buyer contingencies or buyer contract obligations, the seller must always issue a notice to perform before being able to cancel. Okay. Now let's talk about the buyer's right to cancel. Again, that always must be done in writing. And the reasons, right, or the rights to cancel would be seller contingencies. Maybe the seller had some contingencies like finding a replacement property. right? That's a seller contingency. How about a contract obligation? Maybe the seller never gave us our disclosures. That's a contract obligation, right? Same step. Buyer then issues a seller a notice to perform before the buyer can cancel as well. Notice to buyer or seller to perform. So here we go now. Now we're in 14E. So 14E tells us that this notice to perform, number one, it should always be in writing. Number two, it needs to be signed by the seller or buyer, depending who's giving it. And it always gives the other party at least 2 days after delivery. Okay. Now you can lengthen that time. So you could say, I'll go ahead and give them 4 days, right? But you can't shorten it. That's a key. It always has to say, that's why it says at least 2 days. So it can never be shorter than 2 days. That's very, very important. Now, the paragraph also talks about something known as a scheduled performance day. So let's see right in the middle of that paragraph, it says, whether or not the scheduled performance day falls on a Saturday, Sunday, or a legal holiday. So why is it talking about this scheduled performance day? Let me give you an example. So today's Wednesday. Let's just use whatever day it is. So today's Wednesday. So let's just say I'm a listing agent and I know today is the day that the buyer was scheduled to remove their contingencies. Okay. I go to the seller because this is now the time to do that. If we want to stay on track, because if not, what happens to the contingency? We know it continues. So we have to have that conversation. And I say, seller, pursuant right to the contract, I'm letting you know they have not removed the contingencies. We've been asking for it now for a couple days. So now you have the right contractually to issue a notice to the buyer to perform. Okay. Seller says, absolutely, I want to stay on track with whatever the contract says I need to do. Okay. So I'll go ahead and, prepare it. And then we're going to send it out to you for your signature. So seller gets the notice to buyer to perform and signs it today. And either myself or my TC, whatever, sends it to the buyer's agent. Today is day 0. Okay. So the day that it's signed, the day that it's delivered is day 0. So tomorrow, which is Thursday, would be day 1. We said the notice to perform has to give them what? At least how many days? 2 days. Okay. So they have Thursday, which is tomorrow. That's day 1. And then they'd have Friday, which is day 2. But the definitions, when we get to the very end of this RPA, there's a section called definitions, and it talks more about days and counting of days. And it says that technical days ends at 11:59 p.m. Right. Friday at 11:59 p.m. So Monday, right? So technically, though, you're still going to want to follow up. I wouldn't necessarily let it drag to Monday. But the point is that you can't expect then, right, for the seller to be in a position to cancel Friday at all, right? Because that's completely off the table. They had until 11:59 p.m. the buyer does to actually perform. So that's something very important to keep in mind when it comes to the notice to perform timeline. Okay, F, effective removal of contingencies. What does it even mean by, so when we are talking with our buyers and it's time now to have them remove all contingencies, this is why it's so important, right? Like we said in prior sessions that we know each of those contingencies, we understand what it means. Because basically what the paragraph says is it means they're electing to proceed. If we're removing all contingencies, buyer is saying, I'm proceeding to close escrow. Okay, demand to close escrow. So now it's going in an order. So if we kind of feel, right, like we pin down the time period, now we talked about cancellation, but what do we got to do in order before we even cancel? We got to issue these notices, right? The notice to perform. But now here's something else. Demand to close escrow. That's different. So before buyer or seller may cancel this agreement for failure of the other party to close escrow pursuant to this agreement, buyer or seller must first deliver to the other party a demand to close escrow, DCE. And obviously it needs to be signed, and it needs to give the other party, now this is different, it's not 2 days. This one gives the other party 3 days to perform. Now, what we need to understand about the difference between a notice to buyer to perform, or just a notice to perform, versus a demand to close escrow, is a demand to close escrow is literally just for close of escrow. In other words, if you still have contingencies in place, active, you're not going to ever probably get to the demand to close escrow, even if your escrow is supposed to close tomorrow. Because that's why. Well, why? Let's think about that. Why would I not issue a demand to close escrow if I still have contingencies? Well, because the notice to perform is what gives the right. The other party puts the other party on notice and says, hey, unless you do this, or my seller's going to cancel or has the right to cancel. It's what it really is. Seller may, it uses the word may cancel. Doesn't mean they're going to, but seller may cancel. So if you're ever at that point and there's still contingencies, the seller has the right to cancel based on that contingency. You wouldn't issue a demand to close escrow until all contingencies have been removed. Typically, we've seen it happen. We've seen where we get demands to close escrow, but there's still contingencies. But that's not how the contract has it laid out. We would never get to a demand to close escrow if we still have active contingencies. Because we're still in limbo, right? Is the buyer moving forward? Have they not? Why haven't they removed it? Seller, what do you want to do? They haven't removed the contingency. So we're not even at the point of talking about demanding to close. It would be like skipping a step, right? And then the 3 days is exactly the same, okay? Now, let me talk about in regards to the counting of days. However, the final day for performance, and this applies to the notice to perform and the demand to close escrow. Final day for performance cannot land on a Saturday, a Sunday, or a legal holiday. Now, that doesn't mean you don't count it in the days. So in the example that I gave you, right, of the notice to perform, we counted Thursday, we counted Friday. But what happens if it's a demand to close, which gives 3 days? Would we count Saturday? Well, in the number of days, we would, in the counting of days, but then the contract under definition says when you do that, in the counting of days, and that last day, whether it's day 2 or day 3, if it lands on a Saturday, a Sunday, or a legal holiday, it then would roll over to the next business day. Okay, now why is that important? So we have a lot of holidays on Mondays, don't we? If you think about it. So there are times where you can issue either a notice to perform, especially on a Thursday. Be careful. Thursdays are always like the day where you always got to be careful with these notices. Because literally there's times where you issue the notice and we're not talking till about Tuesday where we're able to actually, right, enforce anything. Because if Monday lands on a holiday. So that's where we have to understand how the counting of days works on these notices. Now, H. So unfortunately, right, we're here at this part of the contract where we're still talking about, everything we're talking about right now is all leading up to the possibility of cancellation, right? Notices, demands. Now what happens if we're actually here? The effect of cancellation on deposits. What's super important for us to know is write that bold writing right in the middle of H, 14H. I'm going to read it. It says a release of funds will require, and if you had like a little imaginary pen or like you actually have a pen, this is what I would like for you to write here. Because it's going to tell you the only 3 ways that we could ever get, and the escrow ladies here are pros at this. The only 3 ways we could ever get a release of funds. Our buyer's deposit back. There's only one of three ways. The number one, I'd have you put a number one to where it says mutual signed release instructions from the parties. Okay, that's number one. And that's like the ideal. That's like everybody agrees, right? It's mutual, release the buyer's deposit, everybody walks away. That's number one. The next way is judicial decision. What does that mean? It's a court order. Judicial decision means, right, it comes from a court. That's the second way will ever get a deposit or any funds released. And then the third way is an arbitration award. So you'd put a number three. Yep. You see how it goes in line in that one sentence? Because when you read it all together, it says a release of funds will require mutual signed release instructions from the parties, comma, judicial decision or arbitration award. That's how the sentence reads. So you would just place a 1 next to mutual, a 2 next to judicial, and a 3 next to arbitration award. That's it. If we can't, we have to fit into one of those 3 categories to ever get money out of escrow, okay? And then, of course, there's these fines that could be added to that if they end up pursuing some sort of litigation. Okay, 15 repairs. What do we need to know about? If the seller did happen to agree to make repairs, what the paragraph says is that it has to be done prior to the final verification of condition, which I don't think we ever say, hey, I'm going to go perform the final verification of condition. I think, what do we say? We're going to go do the walkthrough, right? The final walkthrough. So that's what it's saying. So anytime a seller has agreed to make repairs, there should be no confusion as to when that's supposed to be done. It says, repair shall be completed prior to the final walkthrough unless otherwise agreed. And then it talks about good and skillful manner, receipts, all of that kind of stuff, okay? 16, the final walkthrough, final verification of condition. This is not a contingency. It's a right. It's different. So some buyers may elect not to do it, a walkthrough. I mean, if they don't, right? Especially investors, sometimes they just waive it. So it's not a contingency, but it's a right that the buyer has, and it's solely to confirm that the condition of the property has remained substantially the same as of the date of acceptance and repairs were done. Because no, it's a right. They don't have to do it, but the contract gives them the right to do it. Okay. 17, proration of taxes. We don't need to be, like I said, whizzes when it comes to proration of taxes, but we do need to know, and it kind of takes us back to a little bit of our remember when we all studied for the real estate exam, the salesperson and exam. So we do need to have an idea of or understanding of prorations, okay? What we need to let the buyers know and the sellers as well, but it would be something like, buyer, depending what month, right? What month our closing falls on, the escrow will make sure that not just taxes, but if there's HOA payments, right? Maybe there's rents on the property that are being collected. All of that is going to be prorated. So what that means is escrow will calculate if there's any adjustments needed, right? So if the seller has already paid the tax bill, do you guys remember, who remembers the no darn fooling around? Okay, that's the way I remembered it, but this was back 30 years ago, guys. So the way I remembered the way the tax roll falls, first installment, broken up into 2 installments. Oh, right, county. So counties issued the tax bills twice a year. First installment, second installment. First installment is due in November. No. It's late, and they'll charge a late fee in December. So no darn. And then the second installment is due in February. Fooling. And it's late, and they will charge a penalty in April. No darn fooling around when it comes to taxes, always. Okay, so that's where, as long as we kind of know that, then you kind of know when you're closing, you're going to have a good idea of what was due, has it been paid, you know, if we're in November, be careful. It's tricky because did the seller already pay it? Or right, and that's where those conversations with escrow are helpful if you need to get clarification on that. Okay, 18. Brokers and agents. Did we realize that we have our own section in the RPA? Now, session 1, we read brokers and agents are not parties to the agreement. Okay, that's different. We're not parties to the agreement, but we do need to identify some aspects of compensation and scope of duty. Okay, compensation, seller or buyer or both as applicable, agree to pay compensation to broker specified in, this is the key word, in a separate written agreement between broker and that seller or buyer. That is why in the RPA, anything fee related to your commission or to any fees associated with your service would not be anywhere in the RPA because it just says what? In a separate written agreement. Okay? Meaning what? So how do sellers or how do listing agents get paid? A listing agreement, right? If we don't have a listing agreement as a listing agent, there is, right, no agreement for us to get paid compensation. Okay? Separate written agreement. How do we get paid as buyer's agents? BRBC. Separate written agreement. That's what this paragraph is highlighting here. Now, scope of duty. Now, I used to just like going through this here, this paragraph. Check this out. Buyer and seller acknowledge and agree that agent does not decide what price buyer should pay or what price seller should accept, does not guarantee the condition of the property, does not guarantee the performance, adequacy, or completeness of inspection, services, products, or repairs provided or made by seller or others, does not have an obligation to conduct an inspection of common areas or areas off-site of the property, shall not be responsible for identifying defects, areas of the property, or, identifying defects on the property in common areas or off-site, unless such defects are visually observable by an inspection of reasonably accessible areas of the property or are known to the agent, shall not be responsible for inspecting public records or permits concerning the title or use of the property, not responsible for identifying location of boundary lines or other items affecting the property, not responsible for verifying square footage, representations of others, or information contained in investigation reports, MLS, advertisements, flyers, or other promotional material, not responsible for determining the fair market value of the property or any personal property included in the sale, not responsible for providing legal or tax advice regarding any aspect of a transaction entered into between buyer or seller, and shall not be responsible for providing other advice, and this is the key right here, if you want to take from this whole paragraph, shall not be responsible for providing other advice or information that exceeds the knowledge, education, and experience required to perform real estate licensed activity. Buyer and seller agree to seek legal, tax, and insurance, title, and other desired assistance from appropriate professionals. I have plenty, and I still do, after 30 plus years being licensed, I have confidently have said that exceeds my knowledge. That exceeds, right, my experience. If it's something, I don't have experience in all aspects of real estate, and I'm okay saying that. Okay? So all these things, the reason why I read that paragraph line by line is because sometimes we put on those hats that we should not. We are not appraisers. We are not home inspectors. We are not engineers. We are not contractors. We are not, right, CPAs. We are not attorneys. And it's okay. It's okay. What you can very much do is guide and give them the resources, right, of how and the tools of how to do all this. So that's very important, scope of duty. 19, I always give as homework, if you want to go ahead and read 19 actually in Southern California. This is one of those other things too that I realized when I was managing the whole, at one point, the entire state of California, is in Northern California, this contract, even it said, they literally use it as escrow instruction. Okay, so this paragraph 19 in Northern California is the escrow instructions. In Southern California, we're used to having escrow generate escrow instructions for us, okay? So if you want to take time, read it. In California, a lot of it gets overwritten, I should say, by their general provisions. So the whole entire paragraph 19 is all about escrow. Now, 20. Who here puts together maybe like as part of your buyer presentation, a list of service providers? Like, which I think is a great idea. I personally suggest that if you're gonna do that, give at least 3 per category of vendors, right? So if you say, here's the list of service providers, right? Here's 3 home inspection companies, here's 3 whatever, okay? Buyer you choose. But this phrase, I absolutely think it should be, if you do have that, and I know a lot of agents do have that as part of their buyer presentations. This is so important. You could literally just take this same wording in 20 and say, on that list that you're giving out, and copy it. And it says, agents do not guarantee the performance of any vendors, service, or product providers, whether referred by agent or selected by buyer, seller, or other person. Buyer and seller may select any providers of their own choosing. Okay? That disclaimer is super critical when you are giving out, right, or recommending any sort of service providers. Very important. MLS basically just lets all the parties know that we agents, right, we work and we report information and data to the MLS, including images, so that actually will carry on. We don't have control over it after the close of escrow. Attorney's fees, prevailing party. Okay, if there is a dispute, all it says is that prevailing party is entitled to reimbursement of attorney's fees. Now, 23, assignment. Assignment, now they added the word nomination here. This actually it was part of the June 2026 revision, this paragraph here. They added to it quite a bit because we were seeing, and we are seeing, a lot of assignments. Now that's where a buyer attempts to assign the contract, the actual purchase contract, to another buyer. So buyer to buyer, right? Assignee. And what the paragraph wants to highlight is that I actually can do that. Like, it starts off by saying buyer shall have the right to assign all of buyer's interest in this agreement under very specific circumstances. Like, for example, to my wholly owned entity or trust that exists at the time of such assignment. Oh, okay. So let's just say I locked in this deal, right, as a buyer. I got it accepted under Gina Saad. And I'm like, you know what? It makes sense. My CPA told me it's better if I just put it in my corp, right? My corp name. I own the corp. I'm the CEO. I'm right. Okay. That actually just said I have the right. I can assign my interest as long as I wholly own the entity or the trust for estate planning purposes, right? That's not a problem. What becomes an issue later is that if it's not any of those two, wholly owned entity or my own trust, now it has to have seller approval. Okay. What the paragraph says is that the seller then you have to obtain written consent from the seller. The seller has to agree to that assignment. And usually you see those with investor to investor. Okay. Like an investor will lock it in, open escrow, and then all of a sudden they're out there trying to wholesale the deal, right? Shop it around, and they'll bring in another investor and they assign the contract. That requires seller approval. It's the AOAA, which is Assignment of Agreement Addendum. And that's the form where the seller would actually have to agree to that assignment. Okay.
Yes, has to be with the same conditions.
Yes, absolutely. And it actually doesn't fully release the buyer, let's just call it buyer number one, from performance. So someone has to step in and perform if the seller agrees to the assignment. Okay. 24, legally authorized signer. I think we might have talked a little bit about this, but this is if we are dealing with, it doesn't really matter, it could be seller or buyer, but if they are signing on behalf of an entity, okay? So if the buyer was a corp, an LLC, a power of attorney, a trust, I'm trying to think of all the different entities. Huh? A probate, yeah. And the same to the seller, right? It doesn't matter, seller or buyer. If the seller or buyer are any of those, the contract says that we need to have, everybody should have, actually, because it's other party and escrow, within 3 days after acceptance, evidence of authority to act in that capacity. And it gives us, it tells us right here, what are we going to need? Well, if it's a trust, we're going to want the portion of the trust or the certification of trust. If it's a probate, we're going to want letters testamentary or court order. If it's power of attorney, we want a copy of the power of attorney. If it's a corp, we want the resolution or the formation documents of the business entity, if it's an LLC, and so forth. Okay? That, I just say, make it a habit to get, I know it says 3 days, the sooner the better, in my opinion. Okay, because you got a lot of things are tied to that. Number one, are we even dealing with the right person signing everything? Right? If it's a corp or an LLC and we think everything's great, right? When somebody's signing it and we don't have evidence of authority, we want to make sure we're dealing with the person who can actually sign on behalf of those entities. Okay, so let's make sure we get that right away and always deliver it straight to escrow so that they could provide it to the title company. Now, here's the definitions. So definitions, again, take your time, read through it, but I do want to show you the counting days. Okay, the counting days is what we talked about with the notice to buyer to perform, but it actually applies to really anything that involves the necessity of counting of days. Now, I know this is going to get a little technical, but this is really what seals it all together. The first day, it says counting of days is done as follows, unless otherwise agreed, obviously, if it's modified. The first day after an event is the first full calendar date following the event and ending at 11:59 p.m. So if you ever want to know where, how, why do we talk about 11:59 p.m., it's here, okay? For example, if a notice to buyer to perform is delivered at 3 p.m. on the 7th calendar day of the month, or acceptance of a counteroffer is personally received at 12 noon on the 7th calendar day of the month, then the 7th day, or the 7th, is day 0. Remember, like we said, right? If it's delivered, that day that it's delivered is always day 0 for purposes of counting days to respond to the NBP or calculating the close of escrow date or contingency removal date. And the 8th of the month is day 1. So day 7, right? It was the day it was delivered. Day 8 would now be day 1 for those same purposes. All calendar days are counted. Remember, all calendars, including Saturdays, Sundays, holidays, are always counted in establishing the first day after an event. All calendar days are counted in determining the date upon which performance must be completed, ending at 11:59 p.m. on the last day for performance. Let's just call it the scheduled performance day, okay, or performance day. Now, consistent with California Civil Code, after acceptance, if the scheduled performance day for any act required by this agreement, including the close of escrow, lands on a Saturday, Sunday, or legal holiday, the performing party shall be allowed to perform on the next day that is not a Saturday, a Sunday, or legal holiday, and ending at 11:59 p.m. And if you ever want to get clarification on what legal holidays, I've seen people argue over what's considered a legal holiday, what's a federal holiday. You can always, they tell you which code you could go look up, okay? Government codes in regards to what's considered holidays, okay? So we're clear on that. So you count the days because it's all calendar days, but if it lands on a Saturday, if the final day for performance lands on a Saturday, Sunday, or legal holiday, it rolls over to the next day that's not a Saturday, Sunday, and it ends at 11:59 p.m. Okay. So in that example of Monday being a holiday, it's not like we wake up bright and early Tuesday and say, all right, let's start calling. Nope, because they have till what time Tuesday? 11:59 p.m.
So if you close escrow on Friday,
Close escrow? Okay.
on Friday, so the 2 days, it's gonna count, Saturday, Sunday, Monday, but they have to vacate the property.
Now that's different. Vacancy is different because if you notice, the contract addresses vacancy in other areas. Like remember in the grid,
Yeah.
it talks about, it's very specific, unless you modify it. It already says the time. It says it's actually yeah. So no, it used to default to 5. It's actually the time of recording. But if you've allowed a certain amount of days, it still doesn't change. Like you have to be careful with that. I've seen different arguments be made when it comes to that. But that's why it's so important to use SIPs, right? Because SIP talks more about the time for vacancy on those possession days. Okay, so that for me on the definitions is the key part of that section. 27, terms and conditions of offer. What we want to make sure we understand on this is this comes up a lot. The liquidated damages and arbitration of disputes paragraphs. One party initials, the other party doesn't. What happens if my buyer, right, forgot to initial or intentionally didn't initial liquidated damages, but the seller did? What happens, right? Or vice versa. So that's what this paragraph talks about. So this paragraph talks about, amongst other things, but what it really wants to highlight here is let's start off right in the middle where the bold says, and it says, if at least one, but not all parties initial, a counteroffer is required until agreement is reached. So no, if only one party, it doesn't apply. It's not binding, okay? Counter offer. So let's make sure when we're getting our offers back, we're looking at initials. Because if not, a counter offer should definitely be issued to address that.
What would you say? Like, because I had people
Yeah.
when they send me
Yes.
they go, oh, you miss, I send an email, the contract is not.
Yeah.
They said, I need it fully executed so we can move on.
Yeah.
They
So
just
like,
wait, but they end up sending.
so depending who it is, right? So like if you're saying like the buyer,
If I have that listing.
oh, you have the listing? Yeah. So buyer agrees to incorporate, right? Paragraph, we're going to talk, it's the next one, I think I want to say. Paragraph 29, liquidated damages into the agreement.
Yeah, or I counter and said,
Yeah.
seller,
Yeah.
buyer to agree.
Yeah, exact. Perfect. Yes. Okay. Time is of the essence. What does that mean? This is a contract that has very specific deadlines, right? In other words, it's time is of the essence. We have to adhere to those time frames when it comes to this type of contract. And it can be signed in counterparts as well. So what is that? If we had multiple parties, right? They can all sign in counterparts. Now, this is the part, they moved the RPA around. I want to say it was like a year. Was it last year? So they put this now towards the end. I take that back. This is actually a June 2026 revision, okay? Why? Because they kind of thought it was a little messy to have the initials, like, it was like not a little more than midway. So now they just put this right before the signature page. So that we would remember that initials and then signature page, okay? They thought it might be less missed that way, okay? So liquidated damages, what do we need to know about liquidated damages is that it applies, there's only a cap. There's a cap of 3% that the seller can retain as liquidated damages. If the property is a dwelling with no more than 4 units, so if it's 1 to 4, one of which the buyer intends to occupy, so it has to be owner occupied, then the amount retained shall be no more than 3% of the purchase price. Any excess shall be returned to the buyer. Okay, and that's civil code. So, so it shows good faith, right, on the buyer's part, and it also caps it. So 3%. The seller cannot retain more than 3% on an owner occupied 1 to 4 property. That's basically what it's saying. Okay. Does require both parties to initial. That's why we just finished saying if one party initials, then we got to pin it down on a counter offer. And we've had clients not agree, right? And even, I mean, mostly on the arbitration part, which I'm gonna get to next. So 30 is mediation. Now look at mediation. Mediation doesn't have initials. Did you notice that? So 29 liquidated damages has initials, and even 31, which we're going to get to next, has initials. 30 doesn't. So 30 is the parties agree to mediate any dispute or claim arising between them out of this agreement or any resulting transaction before resorting to arbitration or court action. And there's the website if they have to actually get to that step. CAR has a consumer or dispute resolution website where they can find information on that. So interesting, this is automatic. It didn't require initials. So parties, so this contract automatically requires mediation if there's a dispute. Okay. Now, arbitration is different. Arbitration does have initials, and what I want to highlight here in arbitration is B, exclusions. The following matters are excluded from mediation and arbitration. So remember we said mediation is automatic, but there's some items that are actually excluded even from mediation. Any matter that is within the jurisdiction of a probate, small claim, so with the pens, those that have the pens, highlight or circle small claims, or bankruptcy court, unlawful detainer, judicial or non-judicial foreclosure to enforce a deed of trust. Key in there, and which is used pretty regularly, is small claims court. So what that means is, and I think they bumped up the limit, used to be 10,000. I think now it's 12,000. Don't quote me, but it's something like that. They did bump it up. So any matter within the jurisdiction of a small claims court, so let's just say 12,000, it might be 11.5, but let's just say 12,000, can actually even bypass mediation. It says it's excluded from mediation and arbitration. So if there's a dispute between the buyer and seller and it's a matter involving less than $12,000, they don't have to go to mediation and they don't have to go to arbitration if they initialed. They could go straight to small claims court. And that's usually what we see happen. And that's usually for damages, right? So trash left on the property after the close of escrow, buyer had to pay a couple $1,000s to have all the stuff hauled off and feels that they should be reimbursed, rightfully so. They don't have to go to mediation. That's small claims. It was less than $12,000. Okay, so they could go straight and file a small claims action.
That's between buyers.
Yes, always. In fact, that's a good way to take me into the next section in this paragraph is D, 31D, agents. Agents shall not be obligated nor compelled to mediate or arbitrate unless they agree to do so in writing. Any agents participating in mediation or arbitration shall not be deemed a party to this agreement. So anything that has to do with mediation, arbitration of this agreement, you're not a party to. You automatically would, handle that with your broker. Some broker policies is, they don't even respond to, even if you get a demand to attend mediation, arbitration. I'm not saying that you don't respond. I'm just saying always take it to your supervising broker, and see what their policy is on that. Okay. But what does it say? You're not obligated, okay, to even participate in it. This does require initials. So this would fall into one of those categories. If only one party initials, you're going to want to pin it down in a counteroffer. One thing I think is hilarious, 31A, even before I go on to the last page here, is the reason why, I don't know if any of you have ever worked with, have had clients that are attorneys actually, and they will never want this paragraph. Okay, they actually most of them actually just put a big red X over it. And the reason is because if you ever read 31A, it's actually quite funny. An arbitrator, right in the middle of the paragraph, says the arbitrator shall be a retired judge or justice or an attorney with at least 5 years of residential real estate law experience. And attorneys just think they're like, I would never let, some of these attorneys have been practicing a long time. They would say, I'm going to let somebody with at least 5 years of experience decide what's going to happen? Absolutely not. So I always thought that was funny because not until they identified that, I was like, oh yeah, it does say that. Okay. 32. Offer. This is how we wrap up. You see how now the contract kind of ended with right, liquidated damages. Hopefully we never have to get there. Hopefully there's never a matter for arbitration. We're already wrapping up. And now we get to our offer. What I want to highlight here, 32A, it's in bold for a reason. And it says, seller has, the very last sentence, seller has no obligation to respond to an offer made. Okay? Hey, I didn't make it up, right? It's here. So when agents, right, call harassing, what? Your seller never, yeah. Well, first of all, seller has they don't have to. Okay, no, seller has no obligation to respond. They don't have to respond. Now, we would appreciate a rejection or a counter or something, but no, they don't have to respond to an offer made. Now, that's different than something else that's very confusing because agents get that confused with something else that I'm going to show you on the next page, which is called presentation of an offer. Two different things. This, make sure that if we are dealing with the entities that we talked about, that this part is filled. So in this case, it's the buyer section. So if the buyer is an entity, trust, corp, LLC, probate, partnership, a power of attorney, or another type of entity, make sure this is completed. If it's not, then you got to add another form, which is called RCSD. You don't want to have to do that. As long as this is completely filled out, one less form that you have to deal with. Here's your buyer's signatures. Make sure that they properly identify themselves. If they do have authority to sign, make sure they put their title, their capacity. If you have more than 2 signers, don't panic. I wish CAR would actually add, I wish they would have for a long time now, more than 2 lines, but they haven't. They're stubborn. They want to keep it to 2 lines. But the additional signature addendum is what you would use for buyer 3, buyer 4, and so forth. Okay, acceptance. This is where your seller, okay, but what are they doing? If they don't check off one of those, if they don't check off the seller counteroffer box, it's assumed that they are accepting this agreement, this contract. So if you're going to counter, make sure you check off that seller counteroffer box. Make sure this entity portion is completed as well. They sign appropriately. If there's more than 2 signers, you would also attach ASA. Now, this section here, again, agents are not parties to the agreement between buyer and seller. Our relationships are confirmed in paragraph 2, which is on page 1 of this contract. Now look at number 3. This is the part where agents kind of get demanding, and they get a little confused. on what this means. Presentation of offer pursuant to the National Association of Realtors standard of practice. Going back to what you had mentioned about ethics, okay? Very different. It's not that the seller is bound by this. It's the realtors that are bound by this. If buyer's agent makes a written request, so it's not like, hey, you better send me. It's a written request. Seller's agent shall confirm in writing that this offer has been presented to the seller. Does that change that the seller still has no obligation to respond? No, doesn't change that. So let's not be confused. All I have to do, according to my realtor code, is all I have to do is come down here, and presentation of offer even allows me to initial it. Agent or seller initials. Seller's brokerage firm presented this offer to the seller on this date. Does that still say the seller has to respond to the offers? No. Just says I have to show that I presented it. Okay, so that doesn't change what we just read up here. Seller has no obligation to respond to an offer made. Doesn't change that. They still do not have an obligation to respond to an offer made if they choose not to. But what I have to do as a realtor, if a buyer's agent in writing says, Gina, I want evidence that you presented my offer. Okay, here you go. Presentation of offer, initial, and this is the date I presented it. I'm sorry?
You just give that page to the.
Sure. Yeah. Yeah, absolutely. Yeah. Okay. So here, going back to this, on this, I just want to make sure this section is completely filled out. And if you're dealing with more than 2 agents, okay, you could actually, they give lines for 2 agents. That's why I always say more than 2. Some people just still use it, even if it's 2 or more, is the AAA form. Okay, the additional agent acknowledgement. If there's another broker involved, so say it's a co-broker situation. Okay, you're listing or you're representing a buyer, but you're also co-buyer representation with another brokerage. That would be the ABA form, which is the additional broker acknowledgement. Okay, and you fill all this out. So, yeah. So you have 2 brokers?
Yeah.
Yeah, co-listing, okay.
So how do you put it in the MLS?
Well, there's a field, there's a co-listing field in the MLS.
The brokers.
Yeah, there's agent and co. Yeah, yeah. But what I typically get asked about when it's that is whose responsibility. Now that's different. And there's a whole set. That's why I always encourage, it's called the ACS form, which is the Agent Commission Sharing Agreement. Whenever you're dealing with another agent or another broker, I recommend having that contract with your agreements because it outlines responsibilities. Agent Commission Sharing Agreement. Yes, ACS. Okay, because that's where now, trust me, these conversations can get very down a rabbit hole. Whose responsibility, whose sign is going to go up? Is it my sign or your sign? Is it both of our signs? Whose responsibility is it to open the door for the appraiser? Is it me or is it you? What's our split? I thought you said I was going to get 60 and you were going to get 40, but now it's looking a little different. Who's going to pay for the marketing? Are we going 50-50 on them? So those conversations are typically the ones that can get very complicated without a written agreement. Okay, so that I recommend highly using that form. And then the offer not accepted, but this is optional. Didn't we just say a seller has no obligation to respond? But sometimes they choose to. And if they do that, now this would not be agent initials. This is seller initials. No counter offers being made. That is our response. And the offer was not accepted by the seller on that date. And that would be the seller initials. So I want to congratulate you all. That is the final session of RPA Mastery. Give yourselves a hand. You did it. You made it. We literally covered every single page of the RPA and pretty much every single paragraph. We skipped some of the other ones for homework, but you made it through the entire RPA. And in 2 weeks, July 29th, we are gonna do the listing agreement. Mastery of the residential listing agreement. I'm so excited and thank you. It's always nice seeing you guys. Have a wonderful day.
Thank you.
Thank you.